Now that I'm back on my CryptoQ Media channel, I just wanted to give everyone a big hello. My friends, all XRP holders should take heart in this. Our stance against the SEC and their unfounded claims about XRP's security status was justified. The SEC was deemed to be mistaken, and Judge Torres ruled in our favor. Then the issue is settled, it is what it is. Curiously, though, in another case, a judge from a different court system affirmed Judge Torres's decision, referring to Judge Torres's finding in the SEC v. Ripple case. The impact of that decision is already having a profound and long-lasting effect on the cryptocurrency market. It is hard to find the words to describe how monumental that was. We relied on each other throughout. It was the worst, I promise. As XRP holders, we are relieved that we are no longer directly affected by the Ripple scenario, even if it is still far from settled during the remedies phase. But everything is fine because we are in a bull market. I expect that is why we will have fun. Whatever the case may be, I felt compelled to provide you my opinion. After listening to the thoughts of many solicitors, such as Stuart Ripple's chief legal officer, James Murphy Ikes's metal lawman, and Bill Morgan, I have to admit that this is an astounding critique. You will surely appreciate this one after listening to the SEC spout their customary load of nonsense. As the matter of whether an asset is a security is being addressed, this court is methodically destroying the SEC's unfounded arguments. In addition, this is in line with what the community has been saying for quite some time. That is why I already stated that it is a significant triumph for our team. Another judge from a separate court system chimed in to tell us we were incorrect this time. Yeah, you're absolutely correct. Because of my lack of training and expertise in the subject, I will not be offering any financial advice. Before we go any farther, I hope you grasp this. Also, you can't utilize what I say or write to get into any kind of business transaction. As a hobby, I enjoy dabbling in Bitcoin, and I'm just a casual YouTuber. The issue of enjoyment follows. According to this headline from Cointelegraph, the judge has allowed the majority of SEC allegations to proceed with the purchase of that litigation. At least on the surface, that doesn't seem that exciting. You should read the article since it is linked to XRP, even though the title isn't. Allow me to simply provide you with a brief overview of the locations of everything. After this quick introduction, the rest of the film is about delving into its significance. The Ripple case between the SEC and Ripple, as well as the events surrounding XRP, are shaping the future of cryptocurrency in significant ways. A U.S. judge rejected most of the securities regulators' allegations against Binance, a cryptocurrency exchange. Despite the business's best efforts, we will handle claims related to the financing staking program, anti-fraud violations, and BNB sale after its initial coin offering. The claim that former Binance CEO CZ was a control person will also be pursued, according to Judge Amy Berman Jackson's court filing from June 28. Plaintiffs said that Nance was obligated to comply with the Exchange Act's registration requirements. Despite this, the SEC was unable to attain a clean sweep. Ultimately, Jackson chose to dismiss claims related to BNB secondary market sales and all sales related to Nance USD stablecoin. After that, it starts to get interesting, alright. In order for you to fully grasp the case, I felt it would be beneficial to give you some background information. I think it's quite relevant. But everything else is pertinent to what happened in the SEC v. Ripple case and to the will to XRP holders. As reported by Fox Business's Eleanor Terrett. She shared this post. I will try my best to prevent repetition, and the way I've structured the movie shouldn't make it too dull, because I will be presenting the opinions of several lawyers. You've just been hearing the same old stories told over and over again, even though nothing is changing. Not important at all. Eleanor Turret provided the following response when questioned about the recent clarification on the secondary market selling of digital assets. Justice Melissa Berman from the D.C. Jackson just rejected the SEC's assertions, so it's safe to say that BNB token secondary sales are securities. According to the Howey test, ripples were presented by Elisa Torres as proof that the token transfer's practicality was relevant in her Howey verdict. According to her decision, a court in another case clearly said that the government relies on the statement that crypto assets are the embodiment of the investment contract. The nature of the technology and the interconnectedness of the platform were points of contention during the hearing. Additionally, BNB secondary sales cannot be considered investment contracts based on the performance of individual tokens. First things first, we're talking about deals that happen on anonymous marketplaces where neither party may reveal their true name. The embodiment theory, which I have been disproving on this channel, was also brought up by her. Before we even got to the end, I've spent years ripping this thing to shreds, and I know I'm not alone in this. I did it all because I wanted XRP to be legally clear. Thus, XRP is nothing more than a representation of the investment agreement. As I've already mentioned, the SEC is attempting to hide their tracks, and asking him, "Are you claiming XRP itself as a security?" exposes this. Just to reiterate, it is not a security. What on earth is going on here? All he can do, in my opinion, is be the embodiment of it. When you poke your arse, it's the same. Because of your ridiculous stick, you're coming out sounding contradictory. Your little one has laid the egg of a monster possessed by demons. Furthermore, the court emphasized that the government's central argument, which has been advanced throughout the lawsuit, is at odds with the terms of the settlement. We are not asserting that these coins are securities, but rather investment contracts, as is often believed. Furthermore, a brief greeting was sent to mark Ellen's return. This is just a side note. The finance court said outright that the agents, Judge Jackson here, and I can state categorically that the agency's position on the industry in Cook has shifted, and that they have failed to execute a comprehensive regulatory plan. It is really appreciated. For a long time now, the SEC has been using gaslighting tactics with us. I understand fully what you're saying. North Korean leader Kim Jong-un. How awful. In my opinion, it's passable. It is quite clear. Everything is very obvious. The regulations and the standards are crystal clear. But that's not what the courts think. Hi there, Kim Jong-Gensler. When it comes to cryptocurrency, nothing is fully regulated. It is plainly visible to you. Under these circumstances, she remarked. Because of this, you are completely disinterested. You have not been going completely bonkers with your medication regimen. You have been the victim of gaslighting by the SEC throughout this entire ordeal. John Deaton, an attorney, wrote the following after Eleanor Turret's initial article. In addition, he expressed great pride in the fact that he and the 75,000 XRP holders had a significant role in persuading Judge Tour to issue the ruling she did. Judge Torres cited numerous papers, including my amicus brief, as well as the hundreds of affidavits submitted by XRP holders, in her decision that the sales of XRP on the exchange did not violate securities laws. We requested that she rule out XRP as a security, and she has fulfilled that request. At that point, I shall put the state on hold. Of course. Everybody, everywhere, is paying attention. We everyone contributed in our own way. Hundreds, if not thousands, of you filled out affidavits. Judge Torres ruled in favor of attorney John Dean following deliberations from 75,000 clients. The odds are high that you're still actively engaging with social media and frequently reposting stuff, even if you didn't. When we banded together, our combined voices resounded around the world. We can be sure that Judge Torres was aware of that. I still think it had a big impact, even if Ripple had done well without it, because things weren't going well for them in general. Since we were all present, it was clear that she grasped the need of demonstrating that XRP was not a security. To sidetrack a bit, she need not have done that. In spite of all the whining and complaining from the XRP community, I still don't believe she would have. We did, and she was quite good about remembering and responding accordingly. Our community accomplished that. Now everyone else can enjoy the fruits of their labor, which suits me great as I am a proud owner of multiple cryptocurrencies. It means a lot to me that you've subscribed and watched my channel. Later, I will see you.